Welcome back to the show. One of the big stories in the world of entertainment and also in the world of the law is, of course, the ongoing trials of Bill Cosby. They're picking the jury, the latest set of accusations that was made against him by accuser Andrea Constant. She says that she was drugged by Cosby, that he drugged and sexually molested her when she was a Temple University women's basketball administrator at his home in Philadelphia in 2004. He claims the encounter was consensual. The judge in the case has now helped Cosby's defense by ruling that jurors will be able to hear how much he paid her in a 2006 civil settlement, and also by saying that a woman, Marguerite Jackson, can take the witness stand after he had blocked her from testifying at the first trial, which ended in a hung jury because he said her testimony would be hearsay, but said now she can take the stand. What she's going to say, apparently, is that Constant is greedy and is lying. So she's testifying about the credibility of the accuser in this case. So that's a win for Cosby. There's also, interestingly, increasing skepticism on the part sometimes of law enforcement with the notion that you have to always automatically believe every complainant. In fact, there is now pushback in Britain about believing victims automatically when they come forward to police as opposed to acting like an impartial investigator. Is this a tipping point for the way we prosecute these cases? To talk about that is now Joseph Neuberger, 640 Toronto's criminal law analyst. Hi, Joe.
Hi, Tasha. How are you?
Hi. Well, Cosby keeps resurfacing in the news, and it's just kind of an illustration, I guess, to me anyway, of the importance that, no matter what you think of the guy, no matter how guilty you think he is, he does still deserve a fair trial. And sometimes you got to hear all the evidence to have that happen. What do you think of the judge's decision in that case?
First of all, I agree with you. It's always very important to hear the evidence and then decide afterward. So that's an important factor. Look, the ruling to allow this witness to testify about a conversation in which the complainant may have suggested that this was a scheme to get money from Mr. Cosby is relevant evidence that goes directly to the credibility and reliability of the complainant. And so the judge has made an appropriate ruling to allow that evidence to be heard by the jury so that they can make an informed decision at the end of the day.
Yeah, sometimes the accuser will say that, not all the evidence gets in necessarily about what went on. Is this like putting the shoe on the other foot? Has there been a sense that until now perhaps it's the opposite, that you're not allowed to bring evidence against the accuser into court?
Well, there is greater effort now to try and limit what evidence you can call or cross-examine a complainant on. And in Canada, we don't have to go any further than this ridiculous Bill C-51, which is now about to get, royal assent at some point or pass, where, text messages will now have to be disclosed and vetted by a judge. So the movement has been to try and restrict evidence. And if we want to protect the right to a fair trial, if we believe in the presumption of innocence, then evidence that's relevant has to be allowed at trial. And there cannot be a bias because that evidence is being called by an accused.
Now, let's talk about Bill C-51, because one of the instigators for that bill, of course, was the Gomeshi case, where there were a lot of text messages or messages between the accusers, in fact, that undermined their credibility, suggesting that perhaps they had, not colluded, as that's a very strong word, but some people say that, colluded or cooperated in an effort to bring Gomeshi down in this case. Do you think Bill C-51 is an overreaction to that?
Yeah, it's ridiculous, and I think it is a very poor response by the government, who's being quite activist in managing criminal justice issues when they frankly should stay out of it. The Section 276 is working just fine. Judges have an overriding discretion.
Okay, what is Section 276? Because most people will not know what that is.
That's the rape shield provision. So you're not allowed to cross-examine a complainant on other unrelated sexual activities or sexual-related material. That's been in place for a long time, brought about by CBOYA and other cases. And so that is in place appropriately. It's not unconstitutional, and it shields complainants in sexual assault cases from being unduly victimized, if you want, or cross-examined inappropriately with respect to irrelevant issues that would go to what they call the twin myths. What the government wants to do now is exactly those types of messages that Mr. Ghomeshi had kept. Those messages will be prevented from being used at instance. You'll have to disclose them to the Crown, bring a formal application under this same section 276 to have those messages vetted as to relevance. It's absurd in my mind, because if it's about the subject matter of the charge, there has been no bar to it previously, and it will now give disclosure to a complainant who also will be able to have their own lawyer argue whether these messages are relevant or not. It's absurd. It's an attack on the right to make full answer in defense. It's an attack on fairness, and it's simply a knee-jerk reaction in response to the Ghomeshi verdict and the social outcry that happened afterward.
Yeah, I was gonna say, I think that the political climate would seem to be driving that more than the facts as you present it, which is interesting considering the pushback. I want to talk to you about this that's happening in the United Kingdom. Just recently, one of the police officers there, the Metropolitan Police Commissioner, who ironically is a woman, she said that we have to have an open mind when a person walks in and treat them with dignity and respect when they make a complaint about sexual assault. But our job is not all about victims. Our job in investigations is to be fair, be impartial, and when appropriate, bring things to justice. So are we seeing a bit of a pendulum swing now? Because people are saying, well, yes, we want to believe victims, but maybe sometimes they do lie, and this is going too far.
Well, absolutely. In fact, kudos to this commissioner. In fact, this woman officer, Ms. Dick, is the commissioner of the Metropolitan Police in London, and she formally led a review of the policy. And what they have stated is, in order to remain impartial and be investigators, no complaint whatsoever can be treated as truthful. And in fact, a commission which looked into a wrongful, allegation, came out with the recommendation also that the word victim has to be dropped. A victim presumes that something has happened to them, and that is not the case during the course of an investigation. It is extremely important, and this is what we're losing sight of in Canada, which causes me great concern. Any type of investigation must be impartial, must be objective. How can we have impartial, objective investigations in this country where the policy of the police is to, quote, believe victims and refer to them as victims? It perverts the system of justice, and like they've stated in the United Kingdom, it strikes at the very core of the criminal justice process, which will generate miscarriages of justice on a considerable scale.
It's interesting, though, because victims were very much part of the changes that were brought in by the previous federal government, the Conservatives. They brought a much greater emphasis on victims' rights, victim impact statements, this kind of thing. Do you think that that is in part why we now assume that someone is a victim or use that language because they've become more important in the process?
Well, people who are true victims have always been important in the process. They have not been left out. But there was this emphasis by the Conservative government because it panders to votes. If you talk tough on crime, talk about victims' rights, forget about the accused, that gets votes. But the reality is it perverts and damages our criminal justice system, and it presumes guilt against people who are charged. And that doesn't affect an individual or a voter until it's their family or a friend who is charged, or even themselves. So yes, we've seen a progression from the Conservative government. They had that legislation, truth in sentencing and everything else. A number of those mandatory minimums have been struck down. But even worse now, because of the social media campaign that arose right after the Ghomeshi verdict, and the police trying to remain, trying to appease the people who are complainants by suggesting that we believe victims when they come forward, has been a complete perversion of our criminal justice process and damages investigations into criminal allegations. Very, very serious. And I applaud this commissioner in the UK.
Cressida Dick, she's the commissioner of the Metropolitan Police in London. We'll see if this attitude changes here or in other jurisdictions. But in the meantime, I want to thank you very much for bringing your expertise and knowledge to this issue. Joe Neuberger is 640 Toronto's criminal law analyst. Thanks so much, Joe.
Thank you for having me on.